This is part one of a series on judicial precedent. In another video, I talked about the four sources of law, which were the Constitution, the legislature, the administrative agencies, and the courts. Let's talk about the law from the courts, which is called judicial precedent, or the common law, or stare decisis, which is a Latin phrase for let the decision stand. In the other video, I said sometimes judges just make it up. That's a very simple way of saying that judges sometimes must bridge gaps in the law. It is a very serious matter that involves very serious consideration by judges and lawyers and often consumes a lot of time and money by people and government. Here's an example in a case called Vibbert versus Parr Incorporated. The Vibbert case is one we will study again in a few weeks when we study contracts, liens, and certificates of title. It is a decision made by an intermediate court of appeals in Texas in 2006. I say intermediate because the court is in the middle of the judicial pyramid. The case largely concerns certificates of title. Before diving into the judicial precedent of Vibbert, you need some background. Years earlier, Sandra and Joseph Vibbert bought a Nissan Altima. They probably borrowed money to buy it. I say probably because the only thing I really know for sure is that when the Vibberts traded in the Altima in 2001, the Vibberts still owed $9,367.95 to a bank named Norwest. Norwest had an agreement with the Vibberts such that if the Vibberts did not repay the money, then the bank would repossess the car. And, this is very important, Norwest had the certificate of title. In 2001, Sandra and Joseph Vibbert traded in the Nissan Altima for a Mercedes-Benz. The car dealership that took the trade-in promised to pay off what was owed on the Nissan, $9,367.95. I do not know if the promise was in writing or not. I suspect it was not in writing. But what is important is that the Vibberts thought the bank would be paid off. The way it should have worked is that the dealership paid off the bank signed the back of the certificate of title, and sent the certificate to either the dealership or to the Vibberts. And then the Vibberts signed the back of the title, and then somebody took the certificate to the Texas Department of Motor Vehicles, which would then print a clean, new certificate showing who was the new owner of the Altima. But none of that happened. A few days later, the car dealership sold the Altima to a couple named Kuwamoto. Obviously, the Kuwamotos drove off in the Altima without the certificate of title. The bank, Norwest, was not paid off, and the bank started after the Vibberts for the money. As far as I can tell, the bank was never paid because of what happened next. And by the way, the car dealership had a bunch of excuses for not paying the money to the bank, and the Vibberts sued the car dealership, but that's not what this story is really about. That's a separate lawsuit. I suspect the car dealership went out of business eventually and never paid the money, any money, to the bank. As mentioned earlier, the Altima eventually wound up with a couple named Kuwamoto. To buy the car, the Kuwamotos took out a loan from a loan company called Signet. In order to protect itself, Signet wanted the certificate of title. So eventually there was a bank, Norwest, and a loan company, Signet, that both wanted the certificate, both needed the certificate of title on the Altima, and Norwest was still hounding the Vibberts for the money. Why was Norwest hounding the Vibberts and not hounding the car dealership? The bank might have been hounding the car dealership, I don't know, but they were definitely trying to get the Vibberts to pay because Norwest had a contract with the Vibberts. Norwest did not have a contract with the car dealership. I don't know what Signet did to try to get the title, except they eventually hired a company called Parr to fix the problem. Fix is my word. So I don't know if Signet tried to get the title from the dealership or what the dealership told Signet. I would like to know because I feel like this whole mess was caused by the dealership. But in any case, Signet hired Parr. Then things got worse because eventually somebody at Parr, or somebody working for Parr, came up with two documents, both of which might be forgeries. One potentially forged document was a release of lien from Norwest. If it was genuine, the release would mean the bank is giving up its claim to the Altima. But the bank had not been paid, so there was no reason for the bank to give up its claim. It's a long story, but the short version is that the signature on the release said Brenda Bodkin as agent for the bank Norwest. But Brenda Bodkin denied ever signing it. The other potentially forged document was an application for a new certificate of title. It showed it was signed by Sandra Vibbert, but Sandra Vibbert denied ever signing it. No court ever determined who signed those two documents. So in the end, the Vibberts still owed the bank, but the Kuwamotos had the Altima. So the Vibberts sued Parr for conversion, which is a legal term which could mean outright theft. The lawsuit against the car dealership was a separate lawsuit. This lawsuit against Parr was filed in a county court at law in El Paso. Early on in the lawsuit, Parr filed a motion for summary judgment, which is a legal way of nipping a lawsuit in the bud, bringing it to an early end, squelching it, getting it dismissed. But dismissed is not the right word. I use it because it might help you understand that Parr was getting the dispute kicked out of court as quickly as possible, before trial, essentially, and importantly. Parr claimed there was absolutely no evidence that the Vibberts owned the car at any time in question. Parr was saying since there is no evidence, there is no need for a trial. To explain this further, you need to understand conversion better. Some people can sue for negligence, some people can sue for breach of contract, and some people can sue for divorce. It depends on their situation. And if somebody has a piece of property stolen from them, they can sue for a conversion. It's a civil suit, not involving the police or a prosecutor, and the victim must prove 4 elements. The victim must prove 1, the victim owned or had legal possession of the property or was entitled to possession. 2, the defendant unlawfully and without permission assumed and exercised dominion and control over the property to the exclusion of or inconsistent with the victim's rights. 3, the victim demanded the property be returned, and 4, the defendant refused to return the property. If the victim proves all 4, then the court can order the property returned or award money to the victim. And here's the first example of judicial precedent. Where do these 4 elements come from? According to Wikipedia, the law of conversion was established before the year 1554 in England. When the United States separated from England in 1776, the U.S. kept 99% of the laws that had been developed over the centuries in English courts. Adopting the English common law made sense. 1, because it was what people were used to, and 2, simply keeping the old books with the old cases was a lot easier than rewriting it all. And as an aside, then, when Texas became a state, Texas adopted the English common law. So this is part of the lesson. The law of conversion is not written by Congress, by the governor, or by the president, or any of their agencies, and the law of conversion is not in any constitution, but it comes from centuries of court decisions developing the law. Parr claimed there is no way the Vibberts still owned the Altima. The first element was completely untrue, and so there was no conversion. Truthfully, the Vibberts traded in the Altima, but the bank still had a certificate of title showing the Vibberts owned it. The judge in the El Paso County Court at Law agreed with Parr and signed a judgment against the Vibberts. The Vibberts filed an appeal which went to the Court of Appeals in El Paso. The Court of Appeals has 3 judges, and all 3 judges participated in the decision in the Vibberts case. The written decision of the El Paso Court of Appeals will be posted on Moodle if anybody wants to read it for themselves. In its decision, the El Paso Court of Appeals restated the 4 elements of conversion, and it referred to a 1971 case from the Texas Supreme Court as authority for the 4 elements. It did not feel the need to refer to a case from 1554 because most people understand that the Texas Supreme Court has the final say in these matters in Texas now. Taking the first element of conversion, the El Paso Court of Appeals said its job was to read the record from the county court at law and decide if there was any chance of a real dispute whether the Vibberts owned the Altima when somebody forged the title documents. If there is a real dispute, then the case must go to a full trial. But if there is no real dispute, then summary judgment was proper and the Vibberts lose before the trial takes place. To bolster its chosen method of analyzing the case, the El Paso Court of Appeals cited to decisions from courts in other parts of Texas, including, once again, the Texas Supreme Court. Those other courts, including the Texas Supreme Court, all say that summary judgment should be granted against the losing party, that's the Vibberts in this case, if the winning party, par, has proven there is no genuine issue of fact or proven there is no evidence in favor of the loser, the Vibberts. So here's another lesson. The method of deciding an appeal after summary judgment does not come from any statute or code. It comes from procedure developed over many, many years in the Texas courts. Finally, the El Paso Court of Appeals had to face the fact that there was an old certificate of title showing that the Vibberts owned the car. Wasn't the old certificate of title some evidence? There were and are two different laws addressing certificates of title. The laws are Transportation Code Section 501071A, which says a motor vehicle may not be the subject of a subsequent sale unless the owner designated in the certificate of title transfers the certificate of title at the time of sale. A sale without transfer of the certificate is void. Texas Business and Commerce Code Section 2.401B says that unless otherwise expressly agreed by the buyer and seller, title passes to the buyer at the time and place the seller delivers the goods, even though a document of title is to be delivered at a different time or place. These are both laws passed by the Texas Congress, and all courts are duty-bound to follow them, but the laws seem to contradict each other. If the court goes with the Transportation Code, then the sale to the Kuwamotos is void, and the old certificate of title is some evidence that the Vibberts owned the Altima when Par tried to get a new certificate. The Vibberts would win. If the court goes with the Business and Commerce Code, the Kuwamotos became the owners when they signed the loan papers and drove off with the Altima, even though the certificate needed some work, so the Vibberts would lose. And one must feel a little sorry for the Kuwamotos. They could not have anticipated any of this. In the end, the El Paso Court of Appeals spent a lot of time analyzing two cases from other courts. One was a decision called Gallus from 1995, and the other called Pfluger from 1981, both from the Dallas Court of Appeals. In the end, the El Paso Court of Appeals decided the Business and Commerce Code controlled. The court held there was no dispute about it. The Vibberts no longer had any ownership in the Altima. A certificate of title is not conclusive, and in this case, the old certificate meant nothing. Hopefully, though, the Vibberts got some justice from somewhere, hopefully from the car dealership. That's all.